All right, I think everybody is able to hear. So this question is to both the online as well as the offline students. This is the question that I have asked you in the last class. That the first thing that I asked is that, are you sure that are you all citizen of India? And then you are quite confident. All of you said yes, that we are citizen of India. So then I also ask you a question that how do you say that you are a citizen of India? What is the criteria? So let me see how many of you are able to answer this particular question. Yes. What is your name? Princey. Okay. So what is your answer? First, you are sure that you are a citizen of India. And how do you say that? Okay. Citizen. So you are citizenship by virtue of what? By virtue of your birth, by virtue of your descent, because you are born to an Indian parent, or is it by virtue of your birth, because you are born in the territory of India, or is it by virtue of your residence, that is domicile, which you say that you have stayed in India for more than 5 years, or is it is by virtue of all the three? All right. So whatever you said is right. Whatever you told that 5 years of residence and all those things are the people who were deemed to be the citizen at the commencement of the constitution. Say, for example, till 1947, what? We are all ruled by the British. Until 1950, we didn't have a constitution because till 1950, because there was no constitution, there was no concept of citizenship. And 1950, we came out with the constitution. 1950, 26th January, suddenly there's a constitution for our country, independent India. That means on 1950, 26 January 1950 itself, our country has to recognize some of the people as a citizen. You cannot wait for some more time. Whoever is born after this will be a citizen of India. That means on 26 January 1950, somebody has to granted the citizenship. For those purpose, there are certain provisions in the constitution who are resident at that point of time, say 5 years before the commencement of the constitution, they are all automatically given the citizenship. But all of you in this class, including me and whoever is in this class, our citizenship is not decided based on what is called as domicile or residence. There are certain criteria. In fact, for those people after the commencement of the constitution, nothing is specifically given in the constitution. The constitution has only empowered the parliament to make a law. The constitution is giving the power to whom? The parliament to make a law, and by that law to determine the citizenship of the people who are there in India after the commencement of the constitution. Is there anyone in this class who was born before the commencement of the constitution? Definitely not possible. So we are all born after the commencement of the constitution. So after the commencement of the constitution, to determine the citizenship, the parliament has enacted a law. Is anyone aware of that particular law? What is that law? Citizenship Act. Very good. Citizenship Act was passed, which has gone for a number of amendments after that. So our citizenship is determined based on the Citizenship Act 1955. And I'm very sure, unless and until somebody is born outside the territory of India, I already told where and how do you know what is the territory of India? It is there in the constitution. It is there in the constitution, to be very specific, yes, in the schedule 1 of the constitution. Is there anyone in this class, including the online students, you can also answer to this question. Has anyone born outside the territory of India? Or you are all born within the territory of India? It can be in any state, it can be in any union territory, it does not matter. So were you all born in the territory of India? If you're all born in the territory of India, the law says that you will get the citizenship of India by virtue of birth, which is also called as right to soil. That means you are born in the territory of India, so you're eligible to get the Indian citizenship. But it is not that just because you are born in the territory of India, you will be granted the citizenship. That's a primary criteria. In addition to that, certain other criteria has to be satisfied. So if you satisfy all those criteria, you will all eligible to be the Indian citizen by virtue of birth. So tell me whether were you all born in the territory of India at the time of your birth? And at the time of your birth, at least one of your parents should be an Indian citizen. Understood? So you should be first born in the territory of India at the time of your birth. And at the time of your birth, at least one of your parents should be an Indian citizen. And then the other parent should not be an illegal migrant. If all the three conditions are satisfied, then you will be determined, or you will have the right to be an Indian citizen automatically. Okay, it does not require any specialized card or something. Automatically, if you satisfy, the moment you satisfy these conditions, you are citizenship by virtue of what? Citizenship by virtue of birth. So I think in most of your cases, I'm not sure of your personal information, but I can assure you that in most of your cases, both of your parents are Indian citizens at the time of your birth. The same criteria will apply for your parents also, because I don't think our parents are also born before the commencement of the Constitution. So they are also born after the commencement of the Constitution. So you're all citizens of India by virtue of what? By virtue of both, because you are born in the territory of India, and at the time of your birth, your parents were Indian citizen. The law says at least one of the parents should be an Indian citizen, not necessarily both the parents. But then the other parent should not be an illegal migrant. Have you ever heard of this word illegal migrant? What do you understand by this word illegal migrant? Very good. Someone who is entering into our country without the official documents. Okay, somebody entering into India with official document. Probably the official document is what is called as visa. Somebody is entering into India with an official document. Can he be considered to be an illegal migrant? So your opinion is, you are saying that somebody enters into India without any official document, or without the approval given by the competent authority in India, then he is an illegal migrant. But I would say even someone who is entering with official document under certain circumstances can also be called as an illegal migrant. When? If he? No, nothing like that. See, how would he have a permanent resident status, a foreigner entering into India? See, whenever a foreigner is entering into India, the Indian authorities will give him time for which he can stay in India. Whether he is taking a work visa, whether he is coming in a tourist visa. So normally the time will be permitted. And then if he is going to overstay, then he has to get the permit extended. So someone who enters into India without a valid document is also an illegal migrant. Someone who enters into India with a valid document but overstays the time for which he is allowed to stay in India, then also he becomes an illegal migrant. So that means anybody will be a citizen of India by virtue of birth, that they are born in the territory of India. And not only they are born in the territory of India at the time of their birth, and at the same time, their parent should not, one of the parents should be an Indian citizen, and the other parent should not be an illegal migrant. So the moment you satisfy all these criteria, you are automatically eligible to be a citizen of India by virtue of what? By virtue of your birth. And I'm very sure that I think 100% of the people, including me in this class, we are all citizenship of India by virtue of what? By virtue of birth. That does not necessarily mean that someone who is born in the territory of India, only by that criteria he can be given the citizenship. In fact, later I'll take the citizenship, I'll elaborate more on this. Initially, the concept of citizenship by birth was absolute. What does it mean? Initially, the concept of citizenship by birth was absolute. Now it has become very restricted. Initially, after the commencement of the Constitution, the only criteria to grant citizenship by birth is someone is born in the territory of India. Nothing else is taken into consideration. But then that has led to a lot of problem to our country. And then gradually they change this particular law right now. So right now, this is the criteria. So now do you understand that how you all become the citizen of India? By virtue of what is called as birth. But there are a lot of other criteria also. Citizenship by virtue of descent, citizenship by virtue of naturalization, registration, incorporation of territory, so on and so forth, which I'll discuss when I take up the part 2 of the Constitution, that is the citizenship. Okay. So this is one thing that I wanted to clarify. The second thing that I want to clarify is some students yesterday, they came and they asked me a doubt that, sir, you said that none of the judges has been removed in our country till this point of time, but I have heard somewhere that during the prime ministership of Indira Gandhi, some of the judges has been removed. Has anyone heard of this, that the judges has been removed during the tenure of Indira Gandhi in 1970s during the emergency era or something? So that means it's your wrong understanding. The judges has not been removed. Who is the chief of the Supreme Court judge? The Chief Justice of India is the among all the judges, he is the chief in the Supreme Court. Now, can someone tell me how this Chief Justice of India is appointed? Who will appoint the Chief Justice of India? The President has to appoint. As per the Constitution, the President will make the appointment. But who has to be appointed as the Chief Justice of India? Nothing is mentioned in the Constitution. The Constitution does not say anything as to who shall be appointed as a Chief Justice of India. So what has been followed in our country is only a conventional practice. And what is this conventional practice? In appointing the Chief Justice of India, a conventional practice is the outgoing Chief Justice of India. The outgoing Chief Justice of India recommend the name to the President as to who is to be appointed as the next Chief Justice of India. That is just a conventional practice. So the outgoing Chief Justice, who is the present Chief Justice of India? It is just Chief Justice Chandrajut. So whenever he is, I think he's going to demit his office in the month of November or something. November, I think, maybe. So whenever he is going to demit his office, so what he normally does, the convention is, the outgoing Chief Justice of India will recommend the name of the next senior most judge. And then he will be appointed as the next Chief Justice of India. Because there's a seniority for all the judges, depending upon when they are appointed to the Supreme Court. Now, what happened during the Indira Gandhi term in 1973? You might have heard of a case, a very famous case, which we'll subsequently discuss. Have you ever heard of a case which is called as a Keshavananda Bharati case? It is considered to be one of the most important judges, and it is also considered to be one of the cases where the largest number of judges have ever sat in this particular case. Do you know how many judges have sat in this particular case? Any idea? Students who have got any background? 13 judges. 13 judges sat in this particular case, and then they came out with a doctrine which is called as Doctrine of Basic Structure, which I'll subsequently discuss, not an issue right now. But what happened is the government was not happy with this judgment for the reason you will later understand. So the government was not happy with this particular judgment. So what has happened is, after this particular judgment, you know that the president in our country act on the aid and advice of whom? The Council of Ministers, which is headed by the Prime Minister. So what happened after the Doctrine of Basic Structure judgment? Prime Minister Indira Gandhi government has advised the President of India to appoint the fourth senior most judge as the Chief Justice of India. Then after this judgment, there was one Chief Justice of India who retired. And then who should by convention become the next Chief Justice of India? Who is next in line? But the second judge who was next in line was also superseded. The third judge was also superseded. The fourth judge was also superseded. And who was fifth in the line next to the Chief Justice of India was appointed as the Chief Justice of India, because he has given a favorable judgment to the government. If you see this 13 judges, out of these 13 judges, 7 judges were approving the Doctrine of Basic Structure. 6 judges said that there is no basic structure. But then the majority judgment favored what? The basic structure. So among the minority judgment, the judge who was 5th in seniority, or I would say 4th in seniority after the Chief Justice of India, he superseded all the 3 senior most judges, and he was appointed as the Chief Justice of India. The convention was broken. But it is not breaking the constitution. It is only a conventional practice. So because the 4th judge was appointed, what happened to the other 3 judges? They are not willing to continue as the judge, so they resigned from the office. They resigned from the office, thought that it is below their dignity to work under a junior judge, and they resigned from the office. So it is not that they have been removed. So removal is something different, the judges resigning is something different. Understood? So it is only that they have resigned. Resign means they have voluntarily submit the resignation. Removal means they are removed by a motion which is passed in the parliament. So no judge in our country till this point of time, both in the Supreme Court and the High Court, has been removed till this point of time. That has to be quite clear in your mind. All right. Okay. So what is the last thing that you have seen yesterday? Emergency provisions. I think that is the last thing that you have seen. I think there's one question. Let us just complete that particular question, and then I will move on to the next thing. Just have a look into this particular question. So try to answer this question. Very, very important thing. This is many times has been asked in the examination. Just have a look into this particular question. Can anyone answer this question? What is the answer? What is the very crux of a parliamentary system? Accountability of the executive to the legislature. I have already clearly said that India has, in the Constituent Assembly, has gone for a parliamentary system than a presidential system, because we wanted to give more importance to what? Accountability over stability. So what is the answer here? The government is responsible to the parliament and can be removed by it. So by this way, we are ensuring what is called as the accountability. Okay. So this has to be very clear. So this is how UPSC asks a lot of questions these days. So very clear about it. Option B is the answer here. Okay. So now we'll move on to the next thing. Okay, so come to our next handout. You can take your next handout. So we'll move to the next topic. Now we are trying to understand some of the key terms in the polity, which I will subsequently use it again and again. So it should be easy for you to understand as we'll proceed further. Okay, so we'll try to quickly go through all these key terms. I'll try to complete all those things. So first of all, if you look into the constitution, the most important thing in the constitution is sometimes I use a word, a reference, which is called as articles. Then I talk of something which is called as parts. And then there's also something which is called as a schedule. So what do you understand by these articles? And what do you understand by these parts? And what do you understand by these schedule? So that is the first thing that you should have an understanding, because this is something you're going to frequently use it again and again. The constitution, which was drafted by the Constituent Assembly, approved by the Constituent Assembly, came into force on 26 January 1950. And at the commencement of the constitution, how many articles we had? How many parts we had? How many schedules we had? 395 articles, 22 parts, and 8 schedules. What is presently the number that you have got? 467 articles, 25 parts, 12 schedules. And how many amendments have happened over a period of time? 106 amendments. Because of the amendments, the number of articles kept on increasing. Few articles were repealed and few articles has been added. So what do you understand by an article? That's the first thing. Okay, before I put into article, what is the constitution? What is the definition we have seen? What is the simplest way of understanding as to what is a constitution? What did I say? A constitution is a basic rule book. A rule book, when I say constitution is a rule book, this constitution is nothing but it is a collection of rules. It's what? It's a collection of rules. So what is an article? An article is nothing but it is a specific rule in the constitution. Okay, so just write down a line. What is an article? An article contains a specific rule in the constitution. It contains a specific rule in the constitution. For example, Article 1, what did it say? Article 1 says, India, that is Bharat, shall be union of states. So Article 1 describes the name of our country. It's talking about a specific rule. It is saying that the name of our country is India, that is Bharat, and it shall be union of states. Say, for example, I'll take Article 326 of the Constitution, which provides for the right to vote. So each and every specific article is what? Each and every specific article is a specific rule. Now come to part. So if you look into the part, the entire constitution is classified into today 25 parts. So what is a part? Try to understand. A part is nothing but it is a collection of rules which is related to a particular subject matter. Just write down and then I'll explain it. What is a part? A part is a collection of rules or articles. A part is a collection of rules or articles. A part is a collection of rules or articles related to a particular subject matter. Related to a particular subject matter. A part is a collection of rules or articles related to a particular subject matter. So what is an article? An article is a rule. It is nothing but it is a specific rule, I would say. It's a specific rule. But what about a part? A part is collection of rules. Plus related to a specific subject matter. Say for example. Write down example. What is part 2 of the Constitution? There are 25 parts. What is part 2 of the Constitution? Part 2 of the Constitution is titled Citizenship. So this part 2 is containing right from Article 5 to Article 11. So within the citizenship, while each and every article is talking about a specific rule, but in general, what is the entire part is dealing with? In general, the entire part is dealing with the subject matter citizenship. So take the example of part 3. What is the title of part 3? Fundamental rights. Fundamental rights. It is containing from Article 12 to Article 35. Well, each and every article is talking about a specific fundamental right. So each and every article is different. They are talking about different fundamental rights. But in total, they are related to a particular common subject matter, which is fundamental rights. So do you understand as to what is an article? An article is a specific rule book. And those rules which are related to one another, a particular topic is collected and they are made as a specific part. All right. And then come to the next thing, that is schedules. Just write down a line. Schedules are nothing but tables. Schedules are nothing but tables or appendix. Schedules are nothing but tables or appendix placed separately in a legal document. Placed separately in a legal document in order to reduce the complexity of the document. In order to reduce the complexity of the document. In order to reduce the complexity of the document. So do you understand? So what are these schedules? So schedules means, suppose let us assume in the article itself where you are talking about the rule, you'll have to give a lot of information there. Then the legal document may not be properly organized. So in fact, I talk about Schedule 1 of the Constitution. What is the source of the Schedule 1 of the Constitution is Article 1. So you have two ways of presenting the Indian Constitution, whether you say that India, that is Bharat, shall be union of states, and then you write down the names of all the states in Article 1 itself. And then you write down the territory of the entire territory of India in Article 1 itself. Or you can do in Article 1, for further information, you can refer to Schedule 1 in the Constitution, and then you place Schedule 1 separately in the document. So which would look more organized in nature by placing them separately. So that is what is called as a schedule. So schedules are nothing but they are tables, they are appendix. Instead of putting them wherever the article comes, they are placed separately in the Constitution. So schedule, is it part of the Constitution? Is it an integral part of the Constitution? Does the Constitution of India comprises of the schedules? Of course. So today, if you see the Constitution of India, it comprises of what? Articles, parts, and the schedules. Clear about this? All right. So what is the next key term? Okay, so today, as of now, how many articles we have? I'm just repeating it. We have 467 articles. How many parts? We have 25 parts, and then schedules, we have got 12. So this you may also compare in reference to the original Constitution. And then you have done 106 amendments so far. Write down the second topic. What is the second topic? Judicial review. So write down the second topic, judicial review. I think we have already discussed about this judicial review. Can anyone tell me what is your understanding of judicial review? I think yesterday we have discussed about this. Can you quickly tell me what is your understanding of judicial review? Very good. So just write down one small line on that. It is a power given to the courts. It is the power which is given to the courts. It is a power given to the courts to declare the actions of the other two organs of the state. It is the power that is given to the courts to declare the action of other two organs of the state, that is the legislature and executive. It is the power that is given to the courts to declare the actions of the other two organs of the state, that is the legislature and the executive, as null and void. As null and void. What do you mean by null and void? Null and void means that the court is declaring that whatever those actions will have no legal effect. No power, no legal effect. As null and void, if they are, that is very important, if they are violative of the Constitution. If they are violative of the Constitution. Write some examples. Example, Article 13 of the Constitution. Article 13 of the Constitution gives the power to the courts. Article 13 of the Constitution gives the power to the courts to declare any law, to declare any law as null and void, to declare any law as null and void if they are violative of fundamental rights. If they are violative of fundamental rights. If they are violative of fundamental rights. Is fundamental right part of the constitution? So if something is part of the constitution, and if any law is made by the parliament or any law made by the state legislature, and if those laws are violative of fundamental rights, the court can strike down them. And this power is given to the courts under which article? Under Article 13. So, but how are they able to do that? It is they are able to do that their power of judicial. That means they can review the actions of the other two organs of the state, and if they are found to be violative of the constitution, they can be declared to be void. Okay, that is very important. But then the key word is only if they are found to be violative of the constitution. Okay, come to the next thing. What is the next keyword? Amendment. Write down the word amendment. The word amendment generally refers. The word amendment refers. Strike down the word generally. The word amendment refers to. The word amendment refers to changes made in the constitution. The word amendment refers to changes made in the constitution. Article 368 of the constitution, write down one more line. Article 368 of the constitution. Article 368 of the constitution gives a power to. Article 368 of the constitution gives a power to. Gives a power to whom? To amend the constitution. Gives a power to the parliament to amend the constitution. Gives a power to the parliament to amend the constitution. So using this power, so far 106 constitutional amendment has been made. Okay, just you can make it as a note. So amendment generally means what? In the future, if I am saying the word amendment, then that means changes in the constitution. But again, you will have to be very specific here. Amendment generally not necessarily always means amendment to the constitution. If I say constitutional amendment, then it is an amendment to the constitution. If I say amendment to an ordinary law, then it is an amendment to the ordinary law. So amendment generally means changes. So what is the prefix that is there? Whether it is a constitutional amendment, whether it is an amendment to an ordinary law, accordingly you understand where the changes are happening. All right, what is the next word? Rights. So write down the next keyword, that is rights. So just write down simple definition. Rights are nothing but entitlements. Rights are nothing but entitlements or claims. Claims. And individuals can make. Individuals can make in a society. In a society. The sources of the rights. The sources of the rights. Could be from the constitution. The sources of the rights could be from the constitution or through statutory legal documents. So I'm saying that the sources of the right. So this is what you'll have to understand. The sources of the right could be from where? It could be from the constitution or it could be from the other statutory legal documents. Okay, now try to understand. I'm saying this is the constitution. Does the constitution provides us any rights? Does it provide? I would say if the constitution provides us some right, and I am further classifying this into two things. Within the constitution, there is something which is called as part 3. Fundamental rights. This is part 3, let us assume. This is the part 3 of the constitution which provides the fundamental rights. There could be other rights outside part 3 of the constitution. So while both are constitutional rights, but specifically the rights which is guaranteed in part 3 is called as what? Fundamental rights. Apart from part 3, the other rights are merely constitutional rights. This is also a constitutional right, but a constitutional right which is fundamental in character. But the other things are merely constitutional rights. So this is one thing. So here you know that in the last class I have given an example of, say, Article 19, freedom of speech and expression. Right to constitutional remedies to approach the courts in case of violation of fundamental right. So for the other constitutional rights, can you give me some example? Right to vote we have seen, right to property we have seen. So these are all outside part 3 of the constitution. But do we exercise any right today which is not there in the constitution, but still you continue to exercise? Can you give me an example of any right, which I would say, which is through the various laws in our country, or I would say ordinary laws? Okay, so today the right to information, the Supreme Court said it is coming from Article 19. It is implied under Article 19. So you take some of the other rights, which you know that it is not there in the constitution, but it is coming from the ordinary law of the land. So ordinary law of the land means they are called as statute, or you call them as a statutory legal document. So give me any right. You as a consumer, do you have any rights? Do you have any consumer rights? In case of purchasing a substandard product, let us assume, which the manufacturer is saying that this is what is the guarantee we are giving, but then you feel that it is a substandard product. So do you have any rights to enforce that in a court of law? Is there any law in our country? Have you ever heard of what is called as Consumer Protection Act? The Consumer Protection Act empowers every consumer to go to a consumer court if there is any substandard service, or you have purchased a substandard product, or the harm that you have suffered because of consuming any products. So that Consumer Protection Act, which gives you, provides you certain consumer right, that's not coming from the constitution. That's merely what it is, a statutory right. It's a statutory right or a legal right. So write down statutory right or a legal right. Is there any other example that you can give for the statutory right or legal right? Is there any other example that you can give? One is Consumer Protection Act. Do you have the right to file an FIR? If there's any criminal offense that has initiated, or you have suffered some injury, so do you have a right to file an FIR? Of course, you have a right to file an FIR under the Criminal Procedure Code, CRPC. Of course, the name has been changed right now, but yes, I would continue to say that as CRPC because the new name is very difficult for me to pronounce. Okay, so we'll say that CRP. So you have the right to file. You have the right to file an FIR. So that's again what it is, your fundamental, your statutory right. Okay, so basically how the rights are classified. The rights are classified into 3 types, I would say. Can all these rights be enforced in a court of law? Can they be enforced in a court of law? Of course, all these rights can be enforced in a court of law. You say that all these rights are enforced in a court of law, but however, what is the difference when it comes to the fundamental right? You can directly enforce this in a Supreme Court, but in case of other rights, you cannot directly go to the Supreme Court. Okay, just write down the distinction as to what is this fundamental right. So first write down. So you have understood as to what is right. Now come to the topic very quickly, fundamental rights. These are rights which are guaranteed in Part 3 of the Constitution. These are only those rights which are guaranteed in Part 3 of the Constitution. These are the rights which is guaranteed only in Part 3 of the Constitution. These are rights which are guaranteed in only in Part 3 of the Constitution. In case of the violation of the fundamental right, in case of violation of the fundamental right, the affected individuals can directly approach the Supreme Court of India. It is a subset of, write down one more statement, it is a subset of constitutional rights. It's a subset of constitutional rights. Come to the next thing, that is the constitutional rights. Write down the next thing, the constitutional rights. These are rights generally guaranteed in the Constitution. These are rights generally guaranteed in the Constitution. These are rights generally guaranteed in the Constitution, but outside Part 3 of the Constitution. But outside Part 3 of the Constitution. Example, right to vote. Example, right to vote under Article 326. If you want, you can write on Article 326. Now come to the next thing, statutory or legal rights. Statutory or legal rights. Statutory or legal rights. These are rights guaranteed to the members of the community. Statutory or legal rights. These are rights guaranteed to the members of the community by the ordinary laws of the land. By the ordinary laws of the land. Guaranteed to the members of the community by the ordinary laws of the land. By the ordinary laws of the land, that is either by a law made by the parliament or by the state legislature. That is either by the law made by the parliament or by the state legislature. In case of violation of the legal rights, in case of violation of the legal rights, in case of violation of legal rights, although they can approach the courts to seek remedy, in case of violation of legal rights, although they can approach the courts for remedy, but they cannot approach the Supreme Court of India directly. They cannot approach the Supreme Court of India directly. They cannot approach the Supreme Court of India directly. They can seek remedy only through the ordinary hierarchy of courts. They can seek remedy only through the ordinary hierarchy of courts. They can seek remedy only through the ordinary hierarchy of courts. What is the next keyword? Please tell me. So is it clear to all of you what is rights in general and how these rights, which can be legally enforceable, further classified into fundamental right, constitutional right, and other legal rights. So legal right means it is coming from the ordinary law of the land, not from the constitution. And within constitution, specifically in part 3, that is a fundamental right. Right? If the law provides for it. See, the law, where do the right come from? The right comes from the law of the land, the ordinary law of the land. So the law itself will specify where you can approach. If the law provides, okay, you can directly go to the High Court, then only they can directly go to the High Court. Say, for example, in case of Consumer Protection Act, it is giving you the right, but it is not telling you to go to the High Court directly, but rather you have to go to a consumer forum. There's a definite tribunal kind of thing. So the law will say where you can go. So if the law is allowing you to directly go to the High Court, you can go. But if the law is saying that by a way of an appeal, you can go to the High Court, then by way of an appeal, you can go to the High Court. So the law will specify where you can go and which court you can go. But the common understanding we'll have is definitely you cannot go to the Supreme Court directly. Okay. What is the next keyword? Writs. Okay, just write down a line on writs. Have you ever heard of these writs? What do you mean by these writs? Okay, just write down a line. Writs are nothing but which are directives issued by the courts. Writs are nothing but the directives which are issued by the courts. Within bracket, you can write writs are nothing but directives issued by the courts, both Supreme Court and the High Court. Especially in case of violation of the fundamental rights. Especially in case of violation of the fundamental rights. Now listen to me for a moment after writing this. Especially in case of violation of the fundamental rights. So what do you mean by writ? Writ means these are directions which are issued by the courts. And what is the intention? Why the courts are issuing this direction? These writs will be issued by the courts whenever any citizen or any individual approaches the court, informing the court that their fundamental right has been violated. I said that our fundamental rights are enforceable in a court of law. So whenever our fundamental rights are violated, so we can make an application, we can move to the courts. So the courts have to inquire and see whether there is a violation of the fundamental right or not. So for this purpose, whenever we make an application to the court that our fundamental right is violated, so depending upon the nature of right violated, the court can issue different types of writs under the constitution. So basically, what is a writ? Writ is nothing but it's a direction which is given by the courts whenever there is a violation of the fundamental rights. So this writ, which can be issued by the courts, it can be issued by both the High Court and the Supreme Court. Just continue further. Can someone read the statement? What is the first statement? Of fundamental rights. The High Court can issue the writs under Article 226. The High Courts can issue the writs under Article 226. And the Supreme Court can issue writs under Article 32 of the Constitution. So under which Article 226 is for the High Courts. And Article 32 is for the Supreme Courts. Is for the Supreme Court. Is where they can issue the writs. There are different types of writs which can be issued by both the Supreme Court and the High Courts. Okay, so in fact, they can issue 5 types of writs. Write down the types of writs. I'm not going to explain these rights right now because when I take up the fundamental rights topic, I'll explain all these writs in detail. Right now, you just have to know the name, nothing more than that. Okay. So the first type of writ, both the High Court and the Supreme Court can issue both these types of writs. Both the courts can issue. So the first type of writ is writ of habeas corpus. Sorry, H-A-B-E-A-S. Sorry, H-A-B-E-A-S. Habeas corpus. Habeas corpus rather. Habeas corpus. 2. Mandamus. 3. Prohibition. 4. Certiorari. 5. Quo warranto. So these are the 5 types of writs that can be issued by both the Supreme Court and the High Court. So what is the type of writ that they'll issue depend upon the nature of the violation of the fundamental rights. So it is not in every case the same type of writ will be issued. So you can write that these are the writs that can be issued by the Supreme Court and the High Court. The type of writ that will be issued by the courts depends upon the violation of the fundamental rights. So what are these writs? I'll explain that later. You just have to know that, okay, these type of writs can be issued. Now, before I move further, one small note you should be aware of. While the Supreme Court can issue writs only for the violation of the fundamental right, the High Courts can issue. The High Courts under which article they can issue the writs? They can issue writs both for the violation of fundamental rights as well as legal rights. Okay, just write down one more line. While the Supreme Court can issue writs, only for the violation of fundamental rights, well, the Supreme Court can issue writs only for the violation of fundamental rights. The High Courts can issue writs both for the violation of fundamental right as well as legal rights. Is that clear? So what is your basic understanding of the writ? If you look at a little bit of historical background, this writ has emerged from the Constitution of United Kingdom, because you know that they were the first country to have a constitution. Although it was an unwritten constitution from where they emerged. So these are also called as prerogative writs of the king. So initially justice was also administered by the king. The king had a council to administer justice to the people in case of such problems. So in the name of the king, these writs were issued to protect the rights of the people. So as and when the constitution has evolved, now today this writ powers are given to the Supreme Court and High Courts under the Constitution of India, which the Supreme Court can exercise only to protect the fundamental rights. Whereas High Court can use these writs both for the protection of the fundamental right as well as legal right. But when what writ will be issued by the court depends upon the nature of violation of the fundamental rights. Not in every case the same type of writ will be issued. Okay, so that's the basic idea you should have. So come to the next topic. What is the next topic? Yes? Nominal executive. This is a very, very important understanding you should have. Nominal executive. So to understand in a simple way, just listen to me for a moment. Nominal means namesake. Namesake, not a real authority, or he is just a ceremonial authority, not a real authority. It looks glittering and all those things, but nothing inside that. So that's basically what is called as a nominal executive. So that's basically what is called as a nominal executive. Online students, please wait. I'll just complete this topic, and then if you have any queries, I'll take it up after that. All right. So under the Constitution of India, do you know who is the head of the Union Executive? Who is the head of the Union Executive? I'm just repeating the statement again. Who is the head of the Union Executive? For the union, who is the head? We have a union government. So for the entire union, who is the head? So if you say who is the head of the Union Executive, the right answer is the president. The Constitution says the president is the head of the Union Executive. But in general, we call that someone as to who is the head of the government. It is the Prime Minister. Okay, so the executive comprises of the president and then the Prime Minister and the Council of Ministers. The Constitution says that the president is the head of the Union Executive. But then this president who is the head of the Union Executive is just for namesake, or I would say that he is just a nominal executive. President is a nominal executive. Just listen to me and then I'll give you the definition. So the president is just a nominal executive, which also means that although the president is the head of the Union Executive, you should have this understanding: the president cannot do anything on his own. Can the president do anything on his own? Can the president appoint the ministers on his own? Can the president appoint the prime minister on his own? Yesterday we have seen as to how the government is formed in a very first class. Today we are in the 18th Lok Sabha. In the 18th Lok Sabha, can the president appoint anyone as a prime minister after the election is over? Although nothing is mentioned specifically in the Constitution, but as per the Constitutional Convention, who is to be appointed as a prime minister? The leader of the single largest party, which has the majority, or the leader of the single largest coalition, which has got the majority. Okay, after the prime minister is appointed, can the president appoint anyone as a minister as per his wishes? No, on the advice of the prime minister. Once the government is formed, then also the president cannot do anything on his own, because the Constitution says that under Article 74 of the Constitution, this is a very, very important article that you'll have to remember. What is this Article 74 of the Constitution is saying? Although the president is the head of the Union Executive, Article 74 of the Constitution is saying that the president shall act as per the aid and advice of the Council of Ministers. So what the president is supposed to do? The president is supposed to do whatever is advised by whom? By the Prime Minister and the Council of Ministers. So he cannot do anything on his own. So if the president, you are saying that, okay, he is the head of the Union Executive, but he cannot do anything on his own. He's just doing whatever has been advised by the Prime Minister and the Council of Ministers. That means what is the position of the president in our country? He is just a nominal executive. So in that case, who is the real executive? The real executive is the Prime Minister and the Council of Ministers. I would say the Prime Minister heading the Council of Ministers. He is the real executive. So basically, the Constitution of India has made the president just a nominal executive or a ceremonial executive. He is not a real executive. Now that takes us to a question: does it mean that the president has no discretionary power? Does it mean that the president cannot do anything on his own? So I'm taking you to the next question: does the president has got any discretionary powers? What do you mean understand by the word discretion? On his own. Can he do something on his own? How many of you think that the president has no discretionary power because he is just a nominal executive? Or how many of you think contrary? No, the president has some discretionary powers. Veto powers. In fact, you will later understand. Right now, I'm not discussing about the veto powers. The president cannot exercise the veto powers whenever he wants. Under certain situation, he can exercise his discretionary power, but not always. My question is very simple. Does the president has discretionary powers or not? So one thing is very clear by virtue of Article 74, which is saying that the president shall act in accordance with the aid and advice of the Council of Ministers. Now, the same article is saying, 74, that if the president is not happy with any of the advice which is given by the Council of Ministers, he can send it once for reconsideration. How many of you know about this? The president can send it once for reconsideration. That is his discretionary power. Sending once for reconsideration, what? The president can send once for reconsideration. How many times he can send it for reconsideration? Send once for reconsideration any proposal which is advised. Send once for reconsideration under the same article. Whatever the advice given, he can send it once for reconsideration. But after such reconsideration, if the same advice is given, the president is supposed to act in accordance with such advice. Then the president cannot say no to that. Suppose if the Council of Ministers are advising something, he is not happy with that. Probably he is having some skepticism on that particular matter. So he is free to send it once for reconsideration. So sending once for reconsideration is his discretionary power. Or I would say it is his constitutional discretion. What do you mean by constitutional discretion? So such discretion is allowed in the constitution itself. That is basically what is his constitutional discretion. But after such advice, he is bound. After such reconsideration, he is bound by the advice which is given by the Council of Ministers. Apart from the constitutional discretion, he can also exercise. So if you talk of the discretion of the president, try to understand here, I'm just making it clear here. If you talk of the discretion of the president, the discretion can be classified into constitutional discretion, and what is called as situational discretion. What is called as situational discretion. So what is constitutional discretion? A constitutional discretion wherein the president exercises such powers from the constitution itself. But whereas what is a situational discretion? A situational discretion is not explicitly mentioned in the constitution. But whenever such a situation arises, then he can exercise a discretion. Then he can exercise such a discretion. So I'll give an example of situational discretion also. Have you ever heard of the word what is called as hung parliament? How many of you in this class has ever heard a term what is called as hung parliament? No? No idea what is hung parliament? Now we are the elections are happening and the results are to be announced by June 4th. Now, unfortunately, which should not happen, let us assume, because if there's a hung parliament, then that's not good for the democracy. For the people of our country, it is not good. Suppose let us assume that on June 4th, when the result is declared, there's a hung parliament. So what is this hung parliament? Hung parliament is a situation that no clear party, no single party is having a clear majority, or no coalition party is having a majority. Suppose let us assume that the BJP is also not having the majority, the Congress is also not having the majority, or the India Alliance is also not having the majority, or the NDA Alliance is also not having the majority. Nobody is having the requisite 272 seats to form the government. In this case, the outcome of such an election is what is called as a hung parliament. So now we have understood earlier, whenever the elections are over, who is supposed to be appointed as a prime minister? The leader of the largest party or the leader of the largest coalition. But what if there's a hung parliament? Nobody has a clear majority. Then this is a situational discretion of the president. It's what? It's a situational discretion that the president can appoint anyone as the prime minister because nobody has a majority. So ultimately, who is the head of Union Executive? The president. So he exercises situational discretion to appoint the prime minister. Okay, he appoints the prime minister, let us assume. Nobody is having the majority, he appoints the prime minister. can that person continue to be the prime minister even without the requisite majority? So he can exercise a situational discretion to appoint the prime minister, but after appointing the prime minister, the president will give him time. Say 1 day, say 1 week, say 1 month. Some time will be given by the president, and within the time he has to prove the majority. What is the requisite majority? In our case, to form the government, 272 members. So he have to prove minimum 272 MPs in the Lok Sabha is supporting his prime ministership. So this is how it happens when there's a hung parliament. So when hung parliament comes, then it becomes a situational discretion. But otherwise, subject to some constitutional discretion and certain instances where he can exercise his situational discretion. Otherwise, the president, as per the Constitution of India, is what? He is just a nominal executive, or he is a ceremonial head, or he is a executive only for the namesake. The real power lies in the hands of whom? The real power lies in the hands of the Prime Minister and the Council of Ministers. Okay, just write down quickly. Just write down quickly. Nominal executive. Nominal executive means executive for namesake. Executive for namesake, or someone who is not a real executive. Or someone who is not a real executive. Someone who is not a real executive. Someone who is not a real executive. The President of India, as per the Constitution, the President of India, as per the Constitution, although head of the Union Executive, is just a nominal executive, by virtue of Article 74 in the Constitution. By virtue of Article 74 in the Constitution. Article 74 of the Constitution mandates. Article 74 of the Constitution mandates the President to act. Article 74 of the Constitution mandates the President to act in accordance with the aid and advice of the Council of Ministers headed by the Prime Minister. Article 74 mandates the President to act in accordance with the aid and advice of the Council of Ministers headed by the Prime Minister. This means the President is generally bound by the advice which is given by the Council of Ministers. This means the President is generally bound by the advice which is given by the Council of Ministers. However, this does not mean the President under the Constitution of India is merely a rubber stamp. However, this does not mean the President under the Constitution of India is merely a rubber stamp, because he can exercise certain constitutional discretion, and certain situational discretion, under certain circumstances. Write down the subtopic constitutional discretion. So write down the subtopic constitutional discretion. A constitutional discretion is something where the President can exercise such discretion as it is allowed in the Constitution. A constitutional discretions are such powers which is exercised by the president because it is allowed in the constitution. Because it is allowed in the constitution. Which is allowed in the constitution. For example, Article 74 of the Constitution. Article 74 of the Constitution allows the president to send any advice which is given by the Council of Ministers. Article 74 of the Constitution allows the president to send any advice given by the Council of Ministers for reconsideration. For reconsideration. So just read that line once again. Anyone? So Article 74 of the Constitution allows the president to send any advice given by the Council of Ministers for reconsideration once. However, after such reconsideration, he is bound to act in accordance with aid and advice of. However, after such reconsideration, he is bound to act in accordance with the advice given by the Council of Ministers. However, after such reconsideration, he is bound to act in accordance with the advice given by the Council of Ministers. He is bound to act in accordance with the advice given by Council of Ministers. Now write down the next thing, situational discretion. Situational discretion. Situational discretion. These are discretionary powers that can be exercised by the president. These are discretionary power exercised by the president. These are discretionary power exercised by the president, but not explicitly mentioned in the Constitution. These are discretionary power exercised by the president, but not explicitly mentioned in the Constitution. He exercised such powers under specific situation, or he exercised such power whenever a specific situation arises. He exercises such discretion whenever a specific situation arises. Whenever a specific situation arises, for instance, when there's a hung parliament, the president can appoint anyone as the Prime Minister of India. When there's a hung parliament, the president can appoint. When there's a hung parliament, the president can appoint anyone as the Prime Minister of India. Not necessarily the single largest party. Not necessarily the single largest party. See, I'm using the word single largest party. What does it mean? I'm just using, just listen to okay, write down and pay close attention to this particular word. I'm saying that whenever there's a hung parliament, the president can appoint anyone as the Prime Minister, not necessarily the leader of the largest party, single largest party. I'm using the word single largest party. Single largest party is different from the word single largest party which is having the majority. There can be a single largest party among all the parties, but even that single largest party is not having the majority. Suppose let us assume some party is having 200 seats or 200 MPs, and that's the largest party. No other party is having 200 seats. So it is not necessarily the president has to appoint the leader of that single largest party as a Prime Minister. When somebody is having no majority, then the president is free to appoint anyone as a Prime Minister. Only that within a specified time, they have to prove the majority, the requisite member. Okay, so that's a situational discretion. Whenever such a situation arises, he can exercise his power. So do you agree that the president under the Constitution of India is what kind of executive? He is merely a nominal executive. So the real power rests in whom? Prime Minister, who is heading the Council of Ministers. Does it mean that the president under the Constitution of India is a mere rubber stamp who is just to act whatever the ministers say? He can exercise certain discretions, and in fact his discretion can be further classified into constitutional discretion and situational discretion. It's a very broad topic. We'll discuss more. I'm just trying to give an essence of this. Now, He can exercise both constitutional and situational discretion. What is constitutional discretion? These are discretion which is explicitly mentioned in the constitution that the president can exercise. But what is a situational discretion? These are not explicitly mentioned, but under certain situation, he can exercise this discretion. That's a situational discretion. All right. So that should be very, very important. Is that clear to all of you right now? Okay, I'll just take a moment. There's one question from the online students. I'll just look into that. Just give me a moment. So there's a question from Vaishali. Can we say that High Court issue writ for the constitutional right also? Yes. See, the High Court can issue writs for both the fundamental rights as well as the legal right, which also includes the constitutional rights. But if the law provides for it. But however, on the other hand, the Supreme Court of India under the Constitution can issue writs for what? They can issue writs only for the fundamental rights. Can anyone think about the logic? The Supreme Court is the highest court, but the High Court is not the highest court. But it appears that more writ powers are given to the High Courts, because High Courts can issue writs for both fundamental as well as the legal rights, including the constitutional rights. But whereas the Supreme Court can issue writs only for the violation of the fundamental rights. That is why it is also said the writ powers of the High Court is much wider than the writ powers of the Supreme Court. So now it does not make much logic when you think a court which is the apex of the judicial system, which is having less writ powers, whereas High Courts are having more writ powers. Why is it so? You cannot burden the Supreme Court. Very good. You cannot burden the Supreme Court. See, the Supreme Court is the highest court and we have just only one court. For all the legal rights, if you directly approach the Supreme Court, then the Supreme Court cannot give importance to the violation of the fundamental rights. So in terms of rights, which is the most important right? Fundamental right. So when there's a fundamental right, you come to me directly. If there's no fundamental right, you go to the lower courts. If you're not happy with the judgment which is given by the lower court, you come to me by way of an appeal, but you do not come to me directly. Okay, so that's the idea. All right. Yes. Any other doubts from the offline students? Online students, any doubt? So if you have any doubt, you can just put it in the chat box. I'll just move forward, and then after some time, probably after covering few more topics, I'll take up your doubt. Okay, what is the next topic? Electoral College. Very good. Electoral College. Because these are the words that we are going to repeatedly use, so you should have an understanding of these keywords. Okay, just write down a line as to what is an Electoral College. The term Electoral College represents a group of people who are entitled to vote. In a particular election. The term Electoral College represents a group of people who are entitled to vote in a particular election. Okay, now tell me, who will constitute the Electoral College when it comes to Lok Sabha elections? So I said, try to understand this concept Electoral College. I said it is a group of people who are entitled to vote in a particular election. But you should understand the fact there are different elections under the Constitution of India. Can someone tell me what are the elections that is recognized under the Constitution of India? So popularly, you know Lok Sabha elections, then you know the assembly elections, and then the local bodies elections are also recognized under the Constitution, the Panchayat elections, the municipal elections. Apart from that, what are the other elections, do you know? Rajya Sabha elections, president election, vice president election, the election of speaker in the Lok Sabha, the election of deputy speaker in the Lok Sabha, the election of deputy chairman in the Rajya Sabha. Similarly, when you take the state legislature, the election of speaker and deputy speaker in the legislative assembly, chairman and deputy chairman in the legislative council. So there are a lot of elections. But popularly, we know only the elections to the Lok Sabha and the legislative assembly or the state legislature. That's what we probably use. So try to understand when you talk of electoral college. So many times this word is used in the constitution, the word electoral college. So what do you understand by the word electoral college? Electoral college means these are group of people who are entitled to vote to a particular election. So when I ask the question of Lok Sabha elections, you know that the constitution allows for universal adult franchise or universal adult suffrage. That means who are all part of the electoral college when it comes to Lok Sabha elections? All the adult individuals who attained 18 years of age. Okay, so this is the understanding you have. Okay, when I take off the legislative assembly election. So legislative assembly elections, who will be the electoral college? Adult of 18 years of age or attained 18 years of age, not more than 18 years of age, attained 18 years of age, but who are resident in that particular state. They will be part of the electoral college. Okay, now I am asking the same question when it comes to the election of the president. For the election of the president, can you and me vote? I'm not exactly asking who is part of the electoral college, but you might have a very preliminary idea that yes, for the presidential election, not necessarily the people are directly voting. Same is the case with the vice president election also. That means under the Constitution of India, there's different electoral college for different elections. Not the electoral college is same for all the elections. There's a different electoral college for different elections. When I use the word electoral college, that means there are group of people. Only those people will be entitled to vote for that particular election. Okay, so write down the example. For example, the electoral college can be different for different elections. For example, the electoral college can be different for different elections. For example, the electoral college can be different for different election. In case of the election of president, in case of the election of president, in case of election of president, it includes only the elected members of both the houses of the parliament. In case of election of the president, what is the electoral college? It includes the elected members of both the houses of the parliament. It includes the elected members of both the houses of the parliament. Within bracket, you can write both Lok Sabha and Rajya Sabha. Okay, so one is elected members of both houses of the parliament, elected members of legislative assembly of the state, elected members of the legislative assembly of the states, elected members of the legislative assemblies of the state. So in a state, there is only one house or two houses. In the parliament, you have two houses, Lok Sabha and Rajya Sabha. In the state, it is one house or two houses. So that means you'll have to understand as per the Constitution of India, while two houses are mandatory in the union legislature, in parliament, two houses are mandatory. But in case of states, two houses are not mandatory. It's only voluntary. If they want to have, they can have two houses. But if they want to have only one house, that is also perfectly fine. So in all the states, there should be legislative assembly. And then there is another house which is called as what? There's something which is called as, so if you take the states, what is mandatory in states is the legislative assembly. So this legislative assembly is mandatory. But what about legislative council, which is the other house? This is only voluntary. It's not necessary. Okay, so what we are writing? Elected members of the legislative assemblies of the state. That means if you take the electoral college for the president, who will be eligible to vote in the election of the president, it includes elected members of both the houses of the parliament, and it includes elected members of the legislative assemblies of the state. So even if they have a legislative council, they are completely excluded. They are not part of it. First of all, there is no reason. If they want to have it, they can have it. Otherwise, no issue. But even if they have it, these members are not part of the electoral college. Write down the third point. The elected members of legislative assembly of the elected members of Legislative Assembly of National Capital Territory of Delhi, the elected members of the Legislative Assembly of National Capital Territory of Delhi and Puducherry. The elected members of the Legislative Assemblies of National Capital Territory of Delhi and Puducherry. The elected members of Legislative Assemblies of National Capital Territory of Delhi and Puducherry. Now see, only these people will be part of the Electoral College. People like you and me are not part of the Electoral College. That's what the Constitution says. Okay, so the example that you have taken is the Electoral College in case of the President is these things. On the other hand, write down, on the other hand, the Electoral College when it comes to election of Vice President includes, on the other hand, the Electoral College in case of election of Vice President, on the other hand, the Electoral College in case of Vice President includes the members of both the houses of the Parliament. On the other hand, the Electoral College of the election of Vice President includes members of both the houses of Parliament. When I say members of both the houses of the Parliament, within bracket you can write both elected as well as nominated members. Both elected as well as the nominated members. Both elected as well as nominated members, but it includes only the members of the Parliament. It does not have any member from the state legislature. Okay, what does it mean by this nominated member? Does anyone have an idea of nominated members? Is there any nominated member? I said in Lok Sabha there are 543 people. In the very first class I said that from the entire country 543 people, or the entire country is divided into 543 constituencies. From every constituency one person can be elected. Is there any nominated member in Lok Sabha today? Nominated MP in Rajya Sabha. Sorry, nominated MP in Lok Sabha. Is there any nominated MP in Lok Sabha today? No idea. Was it there in the original constitution? Was there any provision for nomination in the Lok Sabha? Very good. In the original constitution, there was a provision for nomination of 2 members from the Anglo-Indian community. These were people who have some descendants to the Britishers. 2 members of this Anglo-Indian community could be nominated, but today it is not possible. A constitutional amendment has been carried out and that has been done away with. After 2020, it has been done away with, after the year 2020. So today, try to understand that there are no nominated members. Nominated, you understand the difference between election and nomination. Election means somebody is elected, nominate means directly appointed, no elections in that case. So today there is no provision for nomination in case of Lok Sabha, but is there any provision for nomination in case of Rajya Sabha as per the Constitution of India? Is there any nomination in Rajya Sabha? Even today, 12 members can be nominated in the Rajya Sabha. And who can nominate these members? The President of India can nominate these members who have done exceptional jobs in the area of art, science, literature, social service. From these 4 fields, that is art, science, literature and social service, who have done exemplary services in these areas, they can be directly nominated to the Rajya Sabha. So now come to the Electoral College of Vice President. The Electoral College of Vice President is containing the members of both the houses of the Parliament. It is not making a distinction between elected and nominated member. It includes the members of both the houses of the Parliament. But whereas in case of presidential election, what it is? It includes only the elected members of both the houses of the Parliament, not the nominated members. So the point that I'm trying to stress here is, whenever I use the word Electoral College, in general, what do they mean? These are group of people or set of people who are entitled to vote in a specific election. But then the Electoral College can vary from election to election, and that information is given in the Constitution itself. So similarly, if you take the Electoral College for the Lok Sabha elections, all the people who have attained 18 years of age. Okay, so similarly, if you take the Electoral College for the Legislative Assembly elections, all the people who are attained 18 years of age but who are resident in that particular state. So it may vary from election to election. So the idea is not you to teach all the Electoral College, just to give an idea what is an Electoral College. Okay, so as we'll proceed, we'll try to understand the other types of Electoral Colleges. Please come to the next keyword. Very, very important. First past the post system. Write down. How many of you heard about this particular term? First past the post system. So majorly, if you see under the Constitution of India, two mechanisms to declare who is the winner of the election is followed. Two mechanisms to declare who is to be considered or who is to be declared as the winner of the election is followed. One is the first past the post system, and other is the proportional representation. So first I'll explain the first past the post system, then I'll go to the proportional representation. Okay, you just think of the first past the post system. I'll just give an example. Suppose let us assume that in this class there is an election. Assuming that we wanted to elect a leader of this particular class. Assuming that this class is having 100 voters, 100 students are there. And then we wanted to choose one leader. So probably to the leader, you will all communicate as to when necessarily you wanted to have the test. But that democracy is not going to happen here in the class. So don't take it otherwise. It's just an example that I'm putting it across. So let us assume that the leader is to be chosen. So who will be part of the Electoral College here? All the 100 students will be part of the Electoral College. And then we fix the principle of choosing the leader is based on the first past the post system. That's the principle, let us assume. And then let us assume that there are 4 candidates who are contesting the election. Out of the 100 students, there are 4 students who wanted to contest the election, and only one person will be elected. And then the institute, the LevelUp Institute, which is conducting the election, assume that LevelUp is like the Election Commission of India, which is authorized to conduct the elections, and they will declare the result. And they have made a rule that the winner will be based on the first past the post system. Now, let us assume 100 students are voting. There are 4 people who are contesting the election. Okay. Let us assume A, B, C, and D. Or these people contesting the election. Electoral College, 100 people. College, 100 students. LevelUp is the Election Commission of India. And Anil is the Chief Election Commissioner, let us assume, who is conducting this election. So now who will be declared to be the winner of the election? Out of 100 students, someone to be declared winner, how much minimum number of votes he has to get? 51. How many of you say it is 51? So 51 means you are talking of some majority. But first past the post system is not about the majority. So try to understand, first past the post system does not necessarily need the majority. The first past the post system, if you are applying that principle, it only requires that one of these candidates should get more votes than all the other candidates. Suppose let us assume, now A has got, let us assume 41 votes. B has got how much? Let us assume, so let us assume A has got 40, B has got 30, C has got 20 votes, D has got 10 votes. I think if you sum up all these things, it's 100. Now somebody is saying 51, which is a majority. Nobody has got the majority. So that means in your opinion, is there no winner in the election? But if you follow the principle, if the principle is the first past the post system, then the winner of the election would be whom? It would be A. Why A is considered to be the winner? A is considered to be the winner because A has got more number of votes than the other candidates. So in the first past the post system, all that you have to see is any candidate would be declared to be the winner provided he is getting more number of votes than the other candidates. If he is getting more number of votes than all other candidates, then automatically A would be declared to be the winner. That is basically what is called as the first past the post system. Okay, let me give you a contrary to this. Suppose let us assume there's one more scenario. This is a scenario when all the 100 students are participating in election. But let me give a contrary view. The contrary view is that many of the students in this class are not okay with the idea of leadership in the first place. Why do I need a leader? I have come here to study and I have my own plan. I'll study according to my plan. What is the purpose for a leader? I know what to do. So what has been done is that out of these 100 students, there is also an option of nota, let us assume. What is this nota recently introduced in the election? None of the above option. So none of the above option means 90 candidates, 90 students who are part of the Electoral College, they are choosing that I don't want to vote any of these leaders in this election. So 90 students are voting here. Okay, 90 votes here. And A is getting 5 votes. B is getting 4 votes. C is getting 1 vote. D is getting, okay, I'll make D 1 because he may vote to himself. I'll make C 2 votes. And in this case, I'll make it 3. Okay. 3, I'll make it 4. 4, 3, 2, 1. Okay. But 90% of the candidates have voted to nota. So who will be declared to be the winner of this election in first past the post system? Still A would be considered to be the winner of the election. So the first past the post system, all that you'll have to see how many people have voted in the elections, excluding the nota, in case if nota is there. Apart from that, whoever has got the more number of votes than all the other candidates who are contesting, then automatically that particular candidate would be chosen to be the winner of the election. That is basically what is called as the first past the post system. Now, tell me where this first past the post system is used in our country. Is there in any election we are following the first past the post system to declare the winner? In fact, we are using this first past the post system both in the legislative assembly elections, in Lok Sabha elections, and also in the local body elections. In all the cases, what is the system of election we are using? The first past the post system. Okay, just write down a line. What is first past the post system? It is a system of election in which a candidate will be declared to be the winner. It's a system of election in which a candidate would be declared to be the winner. It's a system of election in which a candidate would be declared to be the winner if he gets more number of votes. If he gets more number of votes, then all other candidates contesting the election. Irrespective of the votes secured by the winning candidate. Irrespective of the votes secured by the winning candidate. Irrespective of the votes secured by the winning candidate. Or in other words, there is no need for any electoral quota. There is no need for any electoral quota or a majority to be achieved. There is no need for any electoral quota or a majority to be achieved in order to declare a candidate. In order to declare a candidate to be a winner in the election. To be a winner in election. The principle of first past the post system. The principle of first past the post system is followed in elections to Lok Sabha. Legislative assemblies, and also in the local body elections. Local body elections, that is within bracket you can write panchayat and municipalities. This principle is followed because of its simplicity. What is the best advantage of this? It is very simple in declaring the winner. It's very simple. That's the only advantage of this. But can anyone tell me any disadvantage of this model? Of the first past the post system? Of course, it's a very simple model. But can you tell me the disadvantage of this model? So I'll give you an example with figures. You try to tell me in 2019 Lok Sabha elections. 2019 Lok Sabha elections, do you know how many party the BJP has won? How many seats, constituencies the BJP has won to the Lok Sabha elections? Lok Sabha elections 2019. You see, Lok Sabha elections 2019, BJP alone has won. Does anyone know how many seats, how many constituencies BJP alone has won? Any idea? I think most of you might be in your school or probably at that point of time, probably, or maybe just you entered into the college, maybe you're not followed it up. 303 seats. They won 303 seats out of 543 seats. They alone have won. And you know how many the first major opposition party has won? The Congress. The Indian National Congress has won 52 seats. No, these things are not important for you to remember. But what is the correlation that I'm trying to bring? Yes, you know that they have won 303 seats, but because of the first past the post system, they won 303 seats. But you know, the absolute number of voters, of the total voters who voted in 2019 election, what percentage of vote the BJP has secured? The BJP has secured 38% of votes. That means whatever the people have voted, out of the people voted across the country, what is the total percentage of votes which has gone to BJP party? 38% votes. And that has resulted in how many seats? 303 seats. But for the Congress, if you see on the other hand, the Congress have taken 20% of the votes. How many votes the Congress have taken? 20% of the votes, but that it has resulted in how many number of seats? 52% of the seats. Now, this anomaly will always exist. Suppose, let us assume, you can see that the BJP has taken twice as much votes as that of the Congress. But that has resulted in seats, if you see, the Congress have just got 1/6 of the seats than what the BJP has got. So, is it reflecting the total percentage, or in other words, is it proportionate to the people who are voting? Is the number of seats, is it proportionate to the absolute number of people who are voting? It is not proportionate. It is happening because of the fact it is based on the principle of first past the post system. That means it is not that the BJP candidates who won the elections by a very big margin, just that they have got more number of votes than the Congress party. In all the constituencies, suppose let us assume the Congress party has got 1 lakh votes, for example, maybe the BJP party has got 1,20,000 votes. And with the margin of this, they have won in most of the things. And automatically, this has resulted in total number of seats more than that of the vote share. But however, for the purpose of simplicity, we are following the first past the post system. So this is exactly what is the first past the post system. Now, there is another method which is called as proportional representation. So come to the next thing, that is proportional representation. We do not follow proportional representation in the Lok Sabha elections, but you should also know what is this proportional representation. What is this proportional representation? Okay, I'm just putting it another way. Now tell me, let us assume for the purpose that in the Lok Sabha 500 seats. This is a hypothetical example. How many seats we are assuming to Lok Sabha? 500 seats. Out of this 500 seats, suppose let us assume BJP, the ruling party today, assume that it is getting 40% votes in the election. We're just seeing in terms of the absolute figures. And let us assume the same figure I'm trying to take. Let us consider that to be 2019 elections. Indian National Congress, let us assume it is getting 20% votes. Let us assume. If this is the result, BJP is getting 40% votes and in the Indian National Congress is getting 20% votes. Let us assume 2019 elections. And suppose let us assume the constitution has allowed for the principle of proportional representation rather than what is called as the first past the post system. So what does the proportional representation means? Proportional representation means the representation of any party in the legislature will be in proportion to the people who have voted to that particular party. Okay, I'm repeating it again. The representation of any party in the legislature would be in proportion to what? It would be in proportion to the people who have voted in the elections to that particular party. So if the total number of seats to be 500, assuming total number of seats to be 500, and then if BJP is securing 40% seats, how many representation will they have in the Lok Sabha? How much representation? This will translate into 200 seats. And if Indian National Congress has got 20% of the votes, this will represent into how many seats? Transform into 100 seats. If this is happening, then that is what is based on the principle of proportional representation. The advantage of proportional representation is that the representation of any party in the legislature would be in proportion to the votes that they have secured. But this is a very complex system. Conducting the election is very complex. But first past the post system, conducting the election is very simple. But the disadvantage of that is that it does not exactly reflect the representation in the legislature. But however, today what we are following is we are following the first past the post system. But we are following the proportional representation in certain other areas, like the elections to the Rajya Sabha, so the election of the president. So in all these cases, we follow what is proportional representation, because these elections are relatively small in size. But in the election to the Lok Sabha and Legislative Assembly local body, what is the principle you are following? First past the post system. And for the election to the president, vice president, Rajya Sabha, we follow the proportional representation. Write down what is proportional representation. It is a system of election in which the representation in the legislature it's a system of election in which the representation in the legislature is proportional to the votes, is proportional to the percentage of votes. It's proportional to the percentage of votes secured by a party. Is proportional to the percentage of votes secured by a party. Is proportional to the percentage of votes secured by a party. In our country, or as per the Constitution of India, the element of proportional representation, is found in some of the elections like president, vice president, Rajya Sabha elections, etc. Okay, I'm using the word an element of proportional representation. So they have certain other things also in addition to that, but then an element, partly this principle is followed in these elections. But for the very important thing is you should have a careful understanding of what is the first past the post system. Is that clear to all of you? What is the first past the post system? So in the first past the post system, there's no need for any majority. All that it is required is they have to secure more number of votes than all other candidates contesting election. Is that clear to all of you? Can I have a louder response? Is that clear to all of you? All right. So come to the next keyword. Online students, is that clear to all of you? All right. So come to the next topic. What is the next keyword? Secret ballot. Very, very important. Has anyone voted in the elections? So for any elections, Lok Sabha elections, Legislative Assembly election, which election? State Legislative Assembly elections. Which state? Assam. So you voted in the state of Assam. So how is your experience when you went to the polling booth? Can you just describe the process very quickly? What happened when you went to the polling booth? Okay, they verified it, and then have they verified your voter ID? And then they allowed you into the polling booth, the place where you have to cast your vote. And then you just describe after entering into the polling booth. What happened? Of course, you don't have to say to whom you have voted, but you just tell me that what happened after you enter into the polling booth. So you have to select, you have to press the button from the EVM. And did you verify this to whom the vote has been cast? There's something which is called as VVPAT, voter verifiable paper audit trail. Did you see the display which Today it has to display for a minimum of 7 seconds, so that you can just verify that the vote has been cast against the person or to the party to whom you wanted to cast the vote. The moment you press the button, a slip will be generated, which you can see, which will be displayed, and then it falls into a enclosed system, which is along with the EVM machine. So you just cast your vote. So now the question is, after you have casted your vote, will there be anyone who will be able to know to whom you have cast your vote? Of course, that you can go and reveal that, but otherwise, were others able to see to whom you are able to cast your vote? No? Are you sure of this? As far as your knowledge is concerned, nobody else will come to know about this. And that system of election is what is called as secret ballot. So what do you understand by secret ballot? So secret ballot means whatever the vote that we exercise, the others will not come to know about this. That is basically what is called as secret ballot. Against the concept of secret ballot, there's something which is called as open ballot. I'll just give a definition, but listen to me, what is called as an open ballot. So what do you understand by open ballot? So in a secret ballot, you are allowed to vote in secret, so as to ensure the secrecy of to whom you have voted. That is what is secret ballot. But there is a certain elections where you vote in open in front of others, where everybody will know as to whom you are voting, whether you are supporting it, whether you are opposing it. Can you give an example of where do you follow this open ballot system? So the concept is quite clear. You are only looking for the examples. So secret ballots mean open voting happens in secret. Open ballot means voting happens in open. So the open ballot happens in the parliament in most of the cases. So for example, whenever a bill is put to vote in the houses, have you ever heard of something which is called as voice vote? The presiding officer has passed the bill with what is called as voice vote. So normally whenever a bill is introduced in the parliament, try to understand it is not that for the bill, the parliament has to vote. Only when there is a majority, then the bill will be passed. Then it will go for the president assent. So whenever a bill is put to vote or any proposal is put to vote, there is someone who is called as a presiding officer. Who is this presiding officer in the parliament? In the Lok Sabha, it is a speaker. In the Rajya Sabha, it is a chairman. So the respective presiding officer will say, okay, how many are you in support of this particular bill? Raise your hand. So then all of them will raise their hand and they'll say yay. That means they are supporting this particular bill. They'll use the word what is called as yay. Yay, and they raise their hand means they are in favor of this. And then the presiding officer will say, okay, how many are opposing this particular bill? Raise your hand and say no. So they will raise their hand and they will say no. So when they say no, openly they are opposing that particular bill. And when they say yes, openly they are accepting and they are supporting the particular bill. So this is a system of what is called as open ballot. So open ballot means voting in front of others, whereas secret ballot means voting happens in the secret. So when as a presiding officer, I know there are 100 students, I know that okay, 70 students are supporting it. I know it is passed with the majority. And suppose I know that only 10 students are opposing it. Again, I know that it has been passed with the majority. So I say that yes, it has been passed. Voting is over. So you can ask me that what if he is not counting it properly? So in case of any doubt, then any of the members in the parliament can raise a concern. Then they can go for recording of votes. If anybody raises a concern with regard to the voice vote or the open ballot, then they can go for the recording of the votes. Otherwise, normally most of the votes happen by what is called as open ballot with regard to passing of the bills and all those things in the House of the Parliament. Okay, that's the difference between what is called as secret ballot and the open ballot. Okay, just write down a line as to what is secret ballot. It is a system in which the voting happens in a secret. It's a system in which the voting happens in a secret in order to ensure the secrecy of the vote cast. In order to ensure the secrecy of the vote cast. Example, the Lok Sabha elections, legislative assembly elections, the panchayat and the municipal elections. The panchayat and the municipal elections. The panchayat and the municipal elections. Now come to the next thing, that is open ballot. It is a system in which the voting happens in an open forum. The voting happens in an open forum in front of all the electors. The voting happens in an open forum in front of all the electors. In case where there is an open ballot, there is no need to preserve. There is no need to preserve the secrecy of the vote cast. There is no need to protect or preserve the secrecy of the vote cast. Example, most of the bills, motions in the parliament, are passed by open ballot. Most of the bills, motions in the parliament are passed by open ballot system. What is the next keyword? Ex-officio. So write down the next keyword, ex-officio. Okay, so before I go to ex-officio, so what are the keywords we have covered till this point of time? I just wanted one of you to go through it quickly. What are the keywords? First, what is the first keyword we have seen? Articles, parts, and schedule. So I'm quite clear you are sure of what is an article, what is a part, and what is a schedule. What is the next thing? Judicial review, which is the power of the courts to review the actions of the other two organs of the state. Next thing, amendment means basically it is called as a change. Constitutional amendment means changes to the constitution. Amendment to ordinary law means changes to the ordinary laws. Next thing, rights. So rights basically they are claims or entitlements, and then we have seen different types of rights. So the constitutional right, the fundamental right, and the legal rights. Next, writs are basically the directives which can be issued by the courts to protect the rights. The Supreme Court can issue writs for the protection of fundamental rights, whereas the High Court can issue writs for protection of both fundamental as well as the legal rights. Yes, somebody from the back, what is the next keyword? Can you also please participate? From the back, yes, what is the next thing? Nominal executive. So nominal executive means namesake. So the president, as per the Constitution of India, is just to be a nominal executive. So does it mean that he has no discretionary powers? He has no discretionary powers. He does have constitutional discretion as well as situational discretion. And we also understand as to what is the difference when it comes to constitutional and situational discretion. Yes, what is the next keyword? There. What is the next keyword? Electoral College. So what is an electoral college? An electoral college means that a group of people who can participate in the elections, who will have the right to vote. Yes, somebody from the back, what is the next keyword after the electoral college? First past the post system. I hope you understood the difference between the first past the post system and the proportional representation. Then the last thing that you have seen, secret ballot and open ballot. Now come to the next concept, that is ex officio. So write down one line as to what is this ex officio. Ex officio means by virtue of one's status or position. Ex officio means by virtue of one's means ONES, not ONC. Okay, by virtue of one's status or position. In other words, write down. In other words, If a person is occupying a public office, by virtue of his status, or position, if a person is occupying a public office by virtue of his status or position, rather than by election, or through any specific recruitment, then he is an ex officio member, or he is appointed by an ex officio capacity, or he is an ex officio member, or he is appointed by an ex officio capacity, Okay, now listen to me. What does it mean by ex officio? So what do you understand? Somebody is not elected to a particular office, or somebody is not recruited to that particular office, but he is still appointed to that particular office. How? By virtue of his status or by virtue of his position. For example, the Vice President of India, somebody is elected as Vice President of India. Whoever is elected as a Vice President of India automatically becomes a Chairman of Rajya Sabha. So nobody is elected as Chairman of Rajya Sabha, or nobody is specifically recruited for the Chairman of Rajya Sabha. But somebody who is the Vice President of India, because he is Vice President of India, his status is what? Because he is the Vice President of India, he automatically becomes a Chairman of Rajya Sabha. And that's why if you see in the Constitution of India, the Vice President is the ex officio Chairman of Rajya Sabha. It is mentioned in the Constitution as what? The Vice President is the ex officio Chairman of Rajya Sabha. He is not elected to Rajya Sabha, or he is not recruited, he has not written any examination, or he has not contested any election, but still he becomes the Chairman of Rajya Sabha. How? In ex officio capacity, because of his status, because of his position, because his position of what? Being the Vice President of India, he automatically becomes the Chairman of Rajya Sabha. Okay, write down. For example, the Vice President of India, is the ex officio Chairman of Rajya Sabha. For example, the Vice President of India is the ex officio Chairman of Rajya Sabha. What is the next keyword? So that means not only for, this is just one example, not only for the Vice President who is ex officio Chairman. So whenever you come across the word ex officio, that means they are not elected there, or they have not gone through any specific recruitment to reach that particular position. It is because by virtue of their status or their position in some other capacity, they automatically become part of this particular job as well. That is basically what is called as ex officio. Is that clear to all of you? Okay, so please write down. What is the next keyword? Veto powers. Write down the veto powers. Veto powers. So write down a line. In general, veto means veto power means the power to reject, a decision, made by a decision making authority. Power to reject or deny a decision made by a decision making authority. Power to reject or deny a decision made by a decision making authority. Now leave out the veto powers of the president. We'll come that to a later stage. But before that, you might be aware of what is called as United Nations Organization. You all have studied that in your schools. Now, in the United Nations Organization, there is something which is called as P5 members. What is the unique power of all these P5 members? They all have veto powers, which is not there to the other members. So these P5 members have got veto powers. That means if they have to take any major decision, It has to be collectively taken by all these 5 members, and individually each and every permanent 5 member have got a veto power. That means even if all the other authorities, all the other countries are okay of imposing a sanction against a particular country, which can be vetoed by one single authority, that is, a particular country can veto it. That's basically what is called as the veto power. So similarly, if you apply that principle in the Indian context, we say normally the president has got what is called as the veto powers. So in which category he has the veto power? So tell me, who is the law-making authority in our country? The parliament. The parliament has the power to make the laws. So for that, there's a long process. We are not concerned about the process right now. But if any law has to be made, it has to go through a long process, and in the process, first it has to be introduced as a bill. You might have heard of the word bill. Bill is nothing but it is a legislative proposal. A proposal has to be introduced. It is introduced in one house, probably in the Lok Sabha, passed in the Lok Sabha, then goes to Rajya Sabha. Can be vice versa also. It can be introduced in the Rajya Sabha, from Rajya Sabha it goes to Lok Sabha, subject to some exception. Most of the bills can be introduced in either houses. It's passed in both the houses. Both the houses, the members of the parliament agree to it, to have such a bill. But the bill is just a proposal. It cannot be enforced in a court of law. To take a transformation just from a proposal to become something as a legal document, it has to be given assent by the president. So after it is passed by both houses, it goes where? To the President of India. So as per the Constitution of India, who is authority to make the law? Parliament. Both the houses are agreeing to that in principle. But despite the fact that both the houses are agreeing to it, then when it comes to the president has still the power to veto this. Or in other words, he has still the power to reject this proposal. And that is exactly what we call as the veto powers. Okay. So what do you have written as veto? In general, veto means the power to reject a decision, power to reject or deny a decision taken by a decision making authority. In the Indian context, or in the context of Indian Constitution, right on, in the context of Indian Constitution, in the context of Indian Constitution, the President of India, because you have written in the context of Indian Constitution, you can write the President can exercise certain veto powers. The President can exercise certain veto powers whenever a bill is presented for his assent. The President can exercise certain veto powers whenever a bill is presented for his assent after passed by both the houses of the Parliament. After it is passed by both the houses of the Parliament. In fact, the President can exercise. Three types of veto powers. The President can exercise 3 types of veto powers. 1, absolute veto. 2, suspensive veto. And 3, pocket veto. So you can exercise absolute veto, suspensive veto, and pocket veto. So these are the veto powers he can exercise. Although, please write down, although. So the President can exercise certain types of veto powers, that is absolute, suspensive, and pocket veto. Although the word veto is nowhere mentioned in the Constitution. This is very, very important. Although the word veto is nowhere mentioned in the Constitution. Although the word veto is nowhere mentioned in the Constitution, but however, these powers are implicit under Article 111 of the Constitution. However, these powers are implicit under Article 111 of the Constitution. That means, what is the basic understanding you should have? The word veto is explicitly not mentioned, but it is coming from which article? It is coming from the rule 111 in the Constitution. So I'm not going to explain you these veto powers. That would be too early. So when I take up the president, I'll explain about all these things. But right now, you should have a basic idea about all these things. Is that clear as to what is this veto power? Come to the next keyword. What is the next keyword? Ordinance. Write down the next thing. Ordinance. How many of you have ever come across this word, ordinance? You are already familiar with this word. Some of you may not be aware also. Probably you have no background in arts, or probably you have completely studied the engineering. So you may not have heard this word also, but not an issue. For those who are already familiar and those who have not learned anything about it, no issue. Now it will be clear to you what is an ordinance. Now, before I get into ordinance, tell me who is supposed to make laws. As per the division of powers we have seen, who is supposed to make laws? The legislative bodies. That means at the union level, the parliament, and at the state level, the state legislature. They are supposed to make the laws. And to make the laws, the legislative bodies has to be in session. That means they have to meet. Do you know that somebody who is elected as an MP, do you think that he will be in the parliament 24/7? If not 24/7, do you think that he will always be there from, say, let us assume 11 o'clock in the morning till 5, 6 in the evening every day throughout the year? Yes? No? In fact, do you know that in the Constitution, there is not even minimum number of days that is prescribed as to how many days they have to meet? There's no such mention in the Constitution. That means they can meet 20 days also, they can meet 30 days also. If they want, they can meet 365 days also. But not necessarily they have to meet all the time. And as per the convention today, the parliament have sessions. Only during the session they go to the parliament. Remaining time they will be in their constituency or they will be somewhere else. It is up to them. It is only during the session. So by some conventional practice today, we have got 3 sessions in the parliament. Do you know what are these sessions? Session means that is the time that they meet. The session means they all come together. So what is the first session every year? The first session in the parliament is the budget session. And then following the budget session, you have something which is called as the monsoon session, which overlaps with the monsoon time in our country. And then you have the winter session, which overlaps with the winter season in the northern part of our country. So it starts with budget session, then monsoon session, then winter session. So the budget session is the longest session. That is normally for 3 to 4 months, or maybe a little more than that. No hard and fast rule. Let us assume 4 months. And then you have the monsoon session, which goes for again 3 to 3.5 months. And then the shortest session is the winter session. That is approximately 2 to 3 months, or maybe 2 months. So the parliamentarians go to the parliament only when there is a session, and only at the time they will sit in the parliament, not all the time. So that means to make a law, you say that the law has to be made where? The law has to be made in the parliament. But suppose, let us assume the parliament is not in session. The parliament is not in session, but there is a need for an urgent law. Where the law can be made? It can be made only in the parliament. Even if the parliament is in session, law making is a very deliberate process. It's a very deliberate, democratic, discussion-oriented process. First, the bill has to be introduced, it will be discussed, it will be put to vote, there will be a lot of debates. There were certain legislations which took years to be passed in the parliament. There are certain legislations that will take a month or 2 to get passed. So first of all, the biggest problem is the parliament may not be in session. And even if the parliament is in session, tomorrow you need a law. Today there's an urgent thing, and to meet out that, tomorrow we need to have a law. Will there be a possibility? There can be a possibility. So suppose you need to have a law immediately. How do you make a law immediately? And the law has to be made by the parliament. Suppose, let us assume the parliament is not in session. And that is why this is an exceptional principle that is given in the Constitution, that a law can be made in the form of an ordinance also. I'm saying ordinance is also nothing but what? It is also a law. So I'm saying that the parliament can also make law, ordinance is also a law. So, but what is the difference between the law made by the parliament and the ordinance? While the law made by the parliament is nothing but it is the normal way, it is a general route. It is a law that is made by a legislative body. But ordinance is nothing but it is a law which is made by the executives. Who is making this law? Executive. Why? Under what condition it can be done? Because the parliament is not in session. And then there's a need for an immediate law. When I say executive, both the president and the governor can issue the ordinance. The president can do it at the national level. The governors can do it at the state level. The president can do it under Article 123. The governors can do it under Article 213. But then what is the difference? In both the cases, it is a law. That ordinance is nothing but it is a law made by the executive. It is not only a law made by the executive, or the appropriate way of putting it is a temporary law made by the executives. Because who is the ultimate lawmaking authority? The parliament. But because the parliament is not in session, to meet the emergency situation, the executives are given the authority to make law, but it is a temporary law. But why do you say it is a temporary law? Any law that is made by the legislature, it's a permanent law. Once a law is made, it is permanent in character. It will always be there. And unless and until this law is again repealed by the parliament has to again introduce a bill and they have to say that we are taking away this law. Otherwise, it's a permanent law. But I'm saying that the ordinance is a temporary law. Why the ordinance is a temporary law? Unlike the law made by the parliament, the ordinance cannot be permanent in character. So whenever the ordinance is made, under what condition it is made? Because the legislature is not in session. So in the meantime, the law is made by the executives in the form of an ordinance, and then this ordinance has to be placed in front of the parliament. Whenever the parliament comes into existence, when it comes to session, it has to be approved by whom? It has to be approved by the parliament within 6 weeks. After the parliament comes into session, if the parliament does not approve this, the ordinance will automatically lapse. When I say lapse, it will not be in effect. So that means only for such a short time, this ordinance can be there. Ultimately, who is the approving authority? Is the legislature. Okay, so write down as to what is this ordinance. Ordinance is a temporary law. Ordinance is a temporary law made by executives. Ordinance is a temporary law made by executives. Ordinance is a temporary law made by executives. This ordinance making power has been conferred upon both the president and the governors. This ordinance making power has been conferred upon both the president and the governors under Article 213. This ordinance making power has been conferred upon both the president and the governors under Article 123 and 213 of the Constitution, respectively. Under Article 123 and 213 of the Constitution, respectively. The ordinance can be issued. The ordinance can be issued when there is an emergency or an urgent situation. The ordinance can be issued when there is an emergency or an urgent situation to have a law. However, the legislature is not in session. The legislature is not in session. Under such circumstances, the president at the national level, and the governors at the state level can issue the ordinances. On the aid and advice of the the respective council of ministers. On the advice of the respective council of ministers. On the aid and advice of the respective council of ministers. However, unlike the law made by the legislature, which is permanent in character, unlike the law made by the legislature, which is permanent in character, the law made by the executives, within bracket you can write ordinances. The law made by the executive within bracket ordinance or temporary in character. Or temporary in character. So what is the basic idea you should have as to what is an ordinance? An ordinance is also a law, but this law has a temporary life unless and until it is approved by whom? Unless and until it is approved by the respective legislature. Suppose if the president issues the ordinance, it has to be approved by the parliament. If the governor issues the ordinance, it has to be approved by state legislature. Okay. State legislature is the appropriate word because state legislature will include both the legislative assembly and the council if they have a council. Okay, so what is the next keyword? Defection. Write down next thing, that is defection. So what we are talking about here is the political defection. I think this is one word that I think most of you might be aware of. It's very much reported in the newspaper and all those things. What do you understand by the word political defection? So there's a provision in the constitution itself to prevent this political defection. First, I just want to understand as to what is your sense of understanding when I use the word political defection, and to whom does it apply? Does it apply to you and me, political defection? So for example, in the first election, let us assume that I have voted to political party A. In the next election, after 5 years, I'm voting to political party B. Does it mean that I have defected? Is it in any way wrong, morally or legally? It's my individual right to freedom of expression. It's up to me because I feel that, okay, this party has not done something good to the country, so I'm changing and I'm voting and I'm giving a chance to another political party to see as to how they perform. If they don't perform well, then I can vote to a political party C as well. This is all right. So this has nothing to do with political defection. So suppose let us assume that there's a politician. He is joining in political party A. He is a member of that particular political party. And he is a membership of that party. And then what he does is, after say few years, he joins another political party. And he gives up the membership of this party and he joins another political party. So is that wrong? Can that be punished? Say for example, I do not know how many of you have seen this. How many of you are aware of this news? In Surat, one candidate who has already been declared elected, even without the election. So how many of you heard of this? So you can just go and check it today. In Surat, in the Surat constituency, already the BJP candidate has been declared elected by the returning officer because there's no other people who are contesting. At the last moment, many of the independent candidates who contested, they have withdrawn their nomination. And then the Congress, which is seen as a major opposition, that candidate has also withdrawn. So only one candidate is contesting the election. So automatically no other candidate is contesting the election in the first place. Automatically he is declared to be winner. Now, the newspaper report is also suggesting today that Congress candidate who has withdrawn after filing the nomination paper is now joining the BJP party. Today it has come in the news. Morning I have seen that it is very likely that he is going to join the BJP party. So I don't remember his name. So can this be seen as a defection? This is also not defection. This is also not political defection. Okay, if this is also not political defection, then what is a political defection? Very good. So that means that you are clearly understanding that people, if they change the party, change and vote in the party, that is not defection. An ordinary political party member, he is joining another political party, that is also not a defection. So when it is called as a political defection, suppose this member who has now the newspaper reports, we are not sure, newspaper reports are telling that he is going to join the BJP party, but had he contested in Congress ticket, and if he had won the election in Congress ticket, and then he has become a member of parliament in the Lok Sabha after winning the election from the Congress ticket, and after winning the election, and then he joins BJP party, then that would amount to what is called as political defection. So when it becomes political defection, that somebody get elected from a particular political party ticket, then after getting elected from a particular party ticket, then he joins another party, giving up the membership of his previous party. Then that is basically what is called as defection or political defection. So political defection applies only if you are part of the legislature and then you change the party. So why this is very wrong? Why this kind of defection is seen as very wrong?
Maybe the person was influenced by the party, or maybe
very good. So it is a mockery of the entire democratic elections, because in our country, people are voting to a particular candidate not because of the credentials of that candidate. It is because they like the party and they want the party to win. So otherwise they would have contested as an independent candidate. Why are they contesting in a particular party? Because party has a vote base and people do vote for that particular candidate more for the party. And if they want that particular party to win, and then you have contested the election from that particular party ticket, you won, and then now you are joining another party, and then it will add up to the value of another party. That means you are making mockery of the entire people who voted you and elected you. So that is why, to avoid this, in fact, there was no law initially to prevent all those things. And initially, if you see, maybe the conscience and the moral behavior of the members was so high who were contesting election that the Constituent Assembly never thought of this. But then starting 1960s and then gradually there was a number of political defections, especially at the regional level. And especially there was a famous saying in Haryana Legislative Assembly which is called as Ayaram Gayaram. So that means there was a political party member who has changed within 15 days 3 parties. Initially he was in one party, then he joined another party, brought that government down. And then within 15 days he joined another party and this government also collapsed. So all these political defections continue to happen. So to prevent all these defections, later they decided that there has to be some punishment for these defectors, and for which a new provision was brought into the Constitution by way of the 52nd Constitutional Amendment Act in 1985, which now inserted a new schedule into the Constitution. There's a separate schedule in the Constitution which talks about this defection. Does anyone know what is the schedule that is related to the defection? 10th schedule in the Constitution. Very good. So what is the punishment for today if people defect from one party to another party? They would be disqualified to be a member of parliament, or they would be disqualified to be a member of state legislature. Okay. So this is basically what is defection. So I'm not discussing much, just wanted to give you an idea as to what is political defection. It's a very big topic which we'll take later, but you should just have an idea as to what is political defection. Just write down a couple of lines as to what is this political defection. Political defection means a candidate who got elected to the legislature, from a particular party ticket, political defection means a candidate who got elected from a particular party ticket, but later joining another party, giving up the membership of the previous party. But later joining another political party, giving up the membership of the previous party. But later joining another party, giving up the membership of previous party. But later joining another party, giving up the membership of previous party. In this case, it would be called as political defection. In this case, it would be called as political defection. In order to prevent political defection, the constitution was amended. In order to prevent the political defection, the constitution was amended by the 52nd Constitutional Amendment Act in 1985. The constitution was amended by the 52nd Constitutional Amendment Act in 1985, which today prescribes disqualification of membership from the legislature, as a punishment for political defections. Which today prescribes disqualification of membership from legislature as a punishment for political defection. When I say today the punishment is disqualification from legislature on the grounds of political defection, which means it will apply both to the members of the parliament as well as the members of the state legislature. So both are liable to be disqualified whenever they defect from one party to another party. But however, it will apply only when they get elected from a particular party ticket. It does not apply to the ordinary members of the party. Okay, so that should be very clear to all of you. So what is the next term? Bills. And after the bill, what it is there? Assent. Okay. So I'll just stop it here. I'll continue with the bills tomorrow. What are the other key terms you have got? Bills. Okay, so there are a few more terms which will take me, I think, roughly around half an hour. Maybe probably tomorrow's class. So I'll tomorrow continue with all these key terms. So try to go through all these key terms, whatever I've discussed. And tomorrow we'll continue with the remaining things. And tomorrow after that, once we complete these key terms, so we're almost done with the basics. So tomorrow after we complete this, I'll just get into the historical background of how the Constituent Assembly was established. And then what happened, what was the basis of establishing this Constituent Assembly, then the drafting of the Constituent Assembly. And after I do that, I'll also give a very brief idea as to what happened before the Constituent Assembly. You know that when the Britishers came to India, do you know how long the Britishers had some kind of influence in our country? They came around somewhere in the 17th century, I would say, starting 17th century or at the end of, I would say, 16th century. And then ultimately when we got independence, it was in 1947. So they almost, their presence was there in our country for 350 years. So if you see this 350 years, for the first 150 years, they are purely traders. Nothing more than that. They just had a commercial interest. And after that 150 years, for the next 200 years, they were having some element of control over India. And in that 200 years, first 100 years, it was through an East India Company. So the British Crown exercised its control over the Indian territories through a company, which is called as the East India Company. And then starting 1857 till 1947, for almost next 100 years, the British Crown directly ruled British India. So once we see the Constituent Assembly, I'll also briefly explain as to what kind of developments have happened over this period of time, because which is also mentioned in the syllabus. It's not very important, but you should have a decent idea about these things as well. So I'll take one class on that. So once we are done with that, probably I'll not be able to complete this in the next class. So next class, maybe I'll start that. So probably next week when you come, one more class we'll discuss on that. And then we'll get into preamble. That is when the Constitution of India starts. Okay. But before I start the preamble, you should have all the basic ideas so that you will be able to move across. And then we'll go through each and every provision in the Constitution very quickly. And then we'll cover most of the things. Okay. But for you to get most of the things and to smoothen the process of your preparation, you will have to go through daily basis, whatever we are teaching in the class. That will have a very smooth sailing. And how do you prepare? That's also very important. It's not that you will only revise whatever I taught today. Today, when you revise this, you should also revise whatever has happened earlier. So before So for the tomorrow when you come to the class, you should revise all the 3 classes. So you should give more time to today, and then you should also revise the previous 2 things. And in this way, if you keep on doing that, then you can just turn the pages. So there will be doubt in certain areas, only the doubts you will look over a period of time. Remaining things, because of the continuous revision, it will automatically get into your mind. All right. So with that, I'll wind up the class for today. And any questions from any of you from the previous class? Online students, any doubts? All right. So I don't think you have a doubt right now. So in case if you have any doubt, so feel free to ask to me. If you are not very comfortable asking it in the class, so after the class also, you please approach me and get your doubts clarified. Okay. So in that way only you will get clarity in the subject. All right. So thank you very much, and we'll again meet tomorrow. Okay. So thank you very much. All the best.